Hello everybody, my name is Andri. I'm the Compliance and Immigration Manager at Sterling Law. In today's video, we're going to talk about the UK right to work processes, procedures, and how this should be implemented in a work environment. We had a lot of changes in the last 6 months. From the end of December 2020, we had the end of free movement rights for EU nationals. From 1st of January, we had the new immigration points-based system, and from end of June 2021 we had the end of EU settlement scheme, which was the deadline. In today's video we're gonna talk about the new Home Office procedures and guidance. We're gonna talk about manual checks and online checks for work, practical steps for implementing the new legislation. So the main areas that you as a business owner or HR manager have to consider are: the first one is the new employer right to work checks supporting guidance, which was published by Home Office on 1st of July 2021. We had also a new right to work checklist 2021. We had the checking a job application right to work portal, and also we have the employer checking service. In this video you will find out when and how to put those ones in practice. The first one is in regards with employer duties. We know that employers should complete the pre-employment right to work checks against all recruits to ensure that they have the right to work in the UK. Also, follow-up checks are required against those with time-limited permission to work in the UK. Where checks are completed in line with Home Office requirements, the employer will secure a statutory excuse to a civil penalty of up to £20,000 per illegal worker should that individual be or may become illegal worker. It's extremely important for you to understand what are the new changes. The main changes are actually referring to right to work checks against EEA or Swiss nationals and any third country family members from 1st of July 2021. Those with EEA or Swiss national, they will have a digital status under the EU settlement scheme, will have to evidence this to the new employer through an online check-in service. Whether they have a settled or pre-settled status will determine whether they will be subject to a repeat right to work checks during their employment. Those with biometric documents and frontier worker permits may also choose to use the online service. So the main changes in regards with the code of practice will refer to EEA and Swiss nationals. It will be implementation of the frontier worker permits, the Irish nationals, and the list A and list B in terms of structure will remain the same, although the list themselves have been amended. It remained the case that list A documents will secure an ongoing statutory excuse, providing that they are checked and recovered correctly. List B documents evidence a temporary right to work, so employers must complete the required repeat checks. Now we're gonna discuss about manual right to work checks. We all know that there are 3 basic steps to conducting manual right to work checks. The first one is to obtain the original version of one or more acceptable documents from the prospective or existing employee. The second one is to check the document validity in the presence of the holder. The third one is to ensure that you make and retain a clear copy and record the date and check was made. On the screen you will be able to see now the new right to work checklist that was released by Home Office at the beginning of July. So you will have the normal details, including the name of person, date of check, and if the check was initial check before employment or follow-up check on an employee. So you will have on the first step the list A and list B that I was referring earlier. Also, on the list B of the documents, it will be a requirement for you to follow up right to work checks. Where you correctly conducted the right to work checks before employment begins by relying on a relevant list A document, you can rely on continuous statutory excuse relating to that individual right to work for the duration of their employment with your organization. This means no further checks will need it to be conducted on the individual while they remain employed by you. However, when relying on documents from List B, you only establish a time-limited statutory excuse and will need to conduct a follow-up check in order to retain protection against civil liability. In either case, you must check that the documents are genuine, that the person in front of you is the rightful holder. You must also make a clear copy of each document cannot manually be altered and retain copy securely. You should keep the copies for the duration of employment and for a further 2 years with a note of the day when the conducted check was made. The next part of our presentation will cover online right-to-work checks. In certain circumstances, employers may be able to conduct free online checks. The Home Office online check-in service is designed to make it easier and quicker for the employees to carry out the necessary checks, providing access to up-to-date and real-time information about the migrant's right to work. It also provides a greater security, as no longer need to rely on physical documents when checking a migrant immigration status, reducing the risk of forged documents being presented to you and exposing you to liability. It will not be possible to conduct an online right-to-work checks in all circumstances. This will depend on whether an individual had an immigration status that can be checked online. Currently, the online service supports checks in respect with non-EEA nationals who hold a current biometric residence permit or a biometric residence card, and for EEA nationals who have been granted status under EU settlement scheme. In order to use the online check-in service, it's not sufficient to view the individual profile in the migrant part of check-in service, where the Home Office has an audit of online checks conducted by employers. To obtain a statutory excuse, you must access the service using employer section entitled View a Job Applicant Right to Work Details, available on gov.co.uk. What you can see now on the screen on the left-hand side, it's exactly what an employee will be able to share with you. So it is a code of mixed of letters and digits, and this code have to be shared with the employer and is valid only for 30 days. For you as an employer, you'll be able to access using www.gov.uk/view right to work, and on this side you'll be able to insert the code. What you will need is just the date of birth of your employee, right to work share code, and obviously your details as an employer. On the right side of the screen, you will be able to see the report from the website. This report, you have to save it and download it and keep it on your records. In terms of right to work checks, we're gonna follow the same 3 steps. The first one is to see the individual right to work details by typing the share code. The second step will be to check that the photograph on the online right to work checks is the individual presenting themselves for work. And the third step, it will be to retain a clear copy of the response provided by the online right to work check-in service. You must retain the profile page confirming the individual right to work, and this page will include the individual photo, the day on which the check was conducted, and obviously your name as an employer. It is important to bear in mind that if someone employs someone following an online check, but this is reasonable apparent that the photograph of that individual is not the individual whom the information provided in the check relates, you may still face a civil penalty in event of illegal working. The last one that we're gonna cover today, it will be the employer check-in service. In most cases, you'll be able to conduct either a manual or an online check. In certain circumstances, however, the individual may not be able to provide their documentation if these, for example, are with Home Office for a pending application. In this case, you will need to contact Home Office employer check-in service to establish a statutory excuse. You must ask Home Office to check the immigration status of that prospective or existing employee, and in any of the following circumstances. The first one is obviously when an individual has submitted an appeal, a review, or an application with Home Office. The individual had an application registration card, or the individual has a certificate of application less than 6 months old. In any of those circumstances, you will receive a report, which is called a verification note, and if that is a positive verification note, you will have a statutory excuse for the next 6 months when you will have to do a follow-up check. The last part that we're going to cover today will be some practical tips for you as a business owner or an HR professional. The first thing that we will advise you is to review the internal right to work guidance, policies, checklist, and other documentation to ensure that you're using the most up-to-date version. The next tip will be for you to ensure that the teams responsible for checks are up to speed in regards with the changes, they are trained accordingly, and they understand when and how to complete a check. Also, it's important for you to review the historic right to work checks and to identify any weaknesses which may undetermine a statutory excuse. The next tip, it will be for you to conduct a full audit of the documentation of the existing employees and to ensure that you're up to date in regards with the trackers. You have systems in place when to do follow-up checks and how to communicate this with your employees. It's also important to ensure that employees are not only familiar with manual right-to-work checks, but also with online right-to-work checks and using employee check-in service. It's quite obvious that Home Office is increasingly moving towards online checks. Therefore, staff may require guidance on how and when to conduct these. If using Home Office right to work checklist for a manual check, please make sure that this is the most recent version and the employees know where to find this. Another thing that will be important to stress out is in regards with COVID-19 concessions for right to work checks. Those have been extended until the end of August 31st, 2021. In the meantime, right-to-work checks can be performed by obtaining photographic or scanned documents, checking them via an online call with that individual, copying them, recording, sign them, and making sure that that right-to-work check is follow-up. The last thing that I would like to stress out is in regards with EU settlement scheme. It is important for you to have a tracker of the existing employees with a pre-settle and settle status, and to ensure that you will know when to do the follow-up checks. I hope you enjoyed today's video and now you're more confident in conducting right-to-work checks. You're up to speed in regards with the most updated checklist of right-to-work. You know when to use the employer check-in service and how to conduct right-to-work checks for employees that they applied under EU settlement scheme. If you enjoyed today's video, give us a like, subscribe, and see you soon.